when you are employing H-1B workers, you should ask, and if you don't, they'll probably tell you if they already have an I-140 petition or they don't. This really matters because it gives you really important information about whether this is an employee that you're going to have to act on immediately to retain, or if it's even going to be possible to retain them without a gap. If they haven't hit the milestones in their green card process to extend beyond their initial 6 years, or if they do have a priority date already and they are able to extend their H-1B until green cards are available in their category. So there are just a ton of workers in the marketplace who are H-1B status and they are born in India. Because there's a big backlog, that is the worst for them. Employers of H-1B workers who want to keep them beyond 6 years have to sponsor them for green cards, except in a couple of circumstances where they can self-sponsor in employment-based categories, or maybe they marry an American or some other reason they get a green card on their own. For the most part, H-1B workers are going to be looking to get a green card through labor certification. If they already have an I-140 approved, it means somebody already did a labor certification for them. And not only that, that it got approved, and then that employer filed an I-140 immigrant petition for them. And the only reason they don't already have a green card is because they haven't been able to do step 3 yet, the adjustment of status. And they probably haven't been able to do step 3 yet because their priority date is backlogged. There just aren't enough slots for them to get a green card. They did what they need to do to get in the line, and they're standing in the line. When you talk to your prospective employee about their I-140, the details that you should be paying attention to are what's your country of birth and what's the priority date. If the priority date is pretty recent, then you're going to know that they are going to have a long wait for a green card. So in May of 2025, the government is accepting adjustment of status applications for people who have a priority date in January of 2013 or earlier. So they've been waiting in the line for 12 years. If your person has like a 2022 or a 2020 or something, 2018, you're going to be waiting a long time. There are a lot of people in line ahead of them. That means you're going to be able to get them a 3-year H-1B, and it probably means that in 3 years, when you renew it, you're going to be able to get another 3-year H-1B. And you can just do that potentially for the entire rest of their career, depending on how long it takes for them to get to the front of the line. Now, if they already have done their labor certification and they already have an I-140, what do you need to do so that when they are at the front of the line, they can get a green card? Well, the new employer that has a job offer for them in the future has to do a new I-140 petition. And in most cases, that means you also have to do a new labor certification. So they haven't lost the utility of their old I-140, but if that job is not available to them anymore, then they need a new basis. So when it's finally their turn at the front of the line to file their adjustment of status and get a green card, they can say, I'm going to this job from this employer that still wants me. Probably not their employer from 15 years ago, 10 years ago. If they don't work there anymore, it's not impossible. It's not forbidden that they can go back and work for that company. But usually, since they don't work there anymore, that company doesn't want them. There's nobody is expecting that they're ever going to go back. But because it exists, they can keep extending the age. Now, here's a twist. What if their old company that got the I-140 approved also withdrew the I-140? Most companies don't withdraw the I-140s for their departed employees, but some do. It used to matter more, but in recent years, it doesn't affect things. If it's been approved for at least 180 days, then even when it's withdrawn, if it's not withdrawn because of fraud, then it's functionally the same as an I-140 that's still in place from an ex-employer that you're not going back to. A withdrawn or canceled I-140 means they can still continue getting those H-1B extensions. It also means that they absolutely can't go back to that old job So they do need their new employer to file an I-140 for them if they're ever going to get to the final holy grail of the green card. But it shouldn't be alarming. So if you look up their receipt number and you see that it's been canceled or withdrawn or revoked, don't freak out. It doesn't mean that this H-1B worker did something bad. It probably just means that that company had a policy of withdrawing those I-140 petitions. So I wouldn't worry about it. When I'm thinking about the timing for starting a new green card process again for a new H-1B worker, first of all, if you weren't able to get a 3-year extension, that is a huge blaring sign that you need to jump on the green card immediately, because that means they don't qualify for 3-year extensions yet. If you can get a 3-year extension, then I think it is fine and reasonable to evaluate them as an employee, make sure it's a good fit, make sure you have an understanding where they're going to fit in at the company before you turn around and start a green card. Because the green card is based around a future job, and it's good to have an understanding of what that future job is going to be. It used to be very common that companies would have a specific policy, like we will not start the green card until you've been here for 3 years or whatever years they said. Now it seems to be much more common that it's actually a bargaining chip in the recruitment process, that companies agree to start the labor certification right away, or they agree that they'll start it after 6 months or 12 months, because employees are sensitive to the fact that it's taking longer and longer to get all the way to an I-140 approval. The other hugely motivating factor for a lot of H-1B workers and their families is that the H-4 spouse cannot qualify for work authorization until the H-1B worker hits certain milestones in their own green card process. So once the H-1B worker has an approved I-140, their spouse can get an H-4 EAD. And then, ironically, the spouse has much broader work authorization than the H-1B worker does. And it's so common that H-1B and H-4 couples are like a power couple where they're both professionals, maybe even in the same profession. And getting that H-4 spouse back to work can be a hugely motivating priority for families to push hard to get to I-140 approval, even if they know that because they are Indian or to a lesser extent Chinese, which are the ones with the big backlogs, they may know, hey, we're going to be stuck in this non-immigrant status for a long time, but being stuck in that status with two wage earners can be a whole lot more tolerable than if only the H-1B worker can earn a salary.